finally the Honorable Supreme Court on 10th December 2024, 10th December 2024, says that we, the petitioners, are eligible to participate in the recruitment process for teachers from class 1 to 8. That is what the Honorable Supreme Court says. And that order, my lord, my ladyship, is the basis of this entire writ petition. My ladyship would first see that order of the Honorable Supreme Court where State of Assam was a party. The order, my ladyship, would find at page 567, annexure P4. That is the basis of the present writ petition and how the state is misinterpreting and misunderstanding the order of Honorable Supreme Court. These two conditions are met, which is you should be in service as on 10th August 17, plus the second that you should have completed the NIOS DLED course within the specified time. You will be considered as a valid diploma holder. On the basis of this, my ladyship, this Honorable Court allowed my writ petition. There were multiple writ petitions filed before this Honorable Court. The order, the relevant order starts at 563.
Yes.
Please see the opening line, ladyship. It is dated 17th June 2025. When counselling starts, the document verification is started from 27 June. I am reading the opening lines. In view of the judgment of Honorable Supreme Court passed on so-and-so, in review petition so-and-so, so-and-so, in case of Vishwanath and others versus State of Uttarakhand, the applicants who have successfully submitted their online application with 18 months DLED from NIOS against the advertisement dated so-and-so are hereby asked to attend the second phase of physical document verification in due course of time when notified in so-and-so, so-and-so, so-and-so as in-service teacher. The problematic part is list of testimonial and documents. This is the problematic part in this particular notification. Now, what are they asking? In my humble submission, beyond the scope of Honorable Supreme Court's order is 1 onwards. Kindly see 1, papers related to proof of in-service as on 10th August 17. First, they are asking for appointment letter and accepted joining report of the applicant. Second, they are asking of minutes of social matching committee of the school in respect of the appointment of the applicant concerned. Third, they are asking for attendance register. Fourth, they are asking for certificate issued by school authority. Fifth, they are asking for salary statements. Sixth, they are asking for UDIS records. I am glad they did not ask me for a selfie sitting in the school that I am teaching. So they asked me 6 documents, which is nowhere mentioned in the Honorable Supreme Court's order. And the document verification has started last Friday. And they say, my ladyship, that all these 6 documents are mandatory. The question that I put to myself is, where does the state get the power to ask for these 6 documents when the Honorable Supreme Court has not said anything on this? However, my ladyship, what is most important, because I had the opportunity of assisting the Honorable Supreme Court in these matters, what was there before the Honorable Supreme Court is very important. Hence, I will request my colleague to just tender a compilation of documents in which this order was passed. Just have a look at those documents. It is a part of the record. What was there before the Honorable Supreme Court was only 1 document, that on this basis you have to prove that you are in service. Over and above that, nothing was required. So kindly have that 1 document compilation, if my ladyship would see. It is the heading of the page, the first cover page says in die number 4961. This is as it is from the Honorable Supreme Court's compilation. In this, my ladyship would just see 1 letter and this was argued by us before the Honorable Supreme Court to get this 10-12 order. Kindly come to page 47. Page 47 may be seen, my ladyship. This is a letter dated 3rd August 2017. My ladyship would see that the second paragraph of page 47, this is a letter issued by MHRD, Ministry of Human Resource Development, School Education and Literacy, Government of India. They are the ones who had introduced this course, which was a one-time course, and this is the first letter by which this guideline are being laid down for this course, which the Honorable Supreme Court considered. Then please see at 47, the second paragraph, which says action to be taken by states and UTs. May I read, ladyship? The first action is states and UTs. So it is the state of Assam will be responsible for ensuring that all in-service untrained teachers in the state and UTs acquire the minimum qualification required under the RTE Act within the proposed extended period till 31st March 19. My ladyship just noted that this is dated 3rd August 17, prior to the course. Then, very, very important, please come to 48. Please come to the very next page. See who has the responsibility of checking whether I was in service or not. Please see Roman 7. Very, very important. Roman 7. All states should prepare a database of such teachers in their state. Who are these such teachers? These are teachers as mentioned above in service. The responsibility to give this data was on the state, not on me. Then please see the next one. 9. Roman 9. State coordinator will enter. It's again the state's responsibility. I am not the one who can just go and apply. The state has to first recommend my name. State coordinator will enter the entire database of untrained in-service teachers in government and private schools on the portal especially prepared by NIOS for this purpose. This portal will also be utilized by the to monitor the process of the training in each state. So it is the state who had to verify in 2017 whether I was in service or not. Now, the most important part of my argument, my ladyship, please see Roman 10. For teachers in private schools, a certificate from the principal would be taken to ensure that the teacher is serving in the school. These certificates will be collected by the state/union territory. And then please see the next one. Once the above information is provided to the state coordinator, then NIOS will provide the following to individual principal. So it is everything between the state and the school. I had nothing to do if I was in service or not. And then to add on to this point, please see page 49 also. 49, there's a timeline given in the bottom. Please see the fourth timeline, which is 20th August 17, which says states and UTs will submit complete database of all in-service untrained teachers in government and private schools to NIOS. I would just pause here for 10 seconds, ladyship. Unless my name was there in the list given by the state to this institute, I couldn't have taken this course. The responsibility to identify me and to give my name was on the state. So therefore, today saying that please give me these 10 documents to show that you are in service is redundant. There is absolutely non-application of mine when these 10 documents are being asked for me, when the responsibility on the state throughout was to give my name, that whether I was in service or not. Plus, my ladyship, just adding on to this, even as per the document which was there before the Honorable Supreme Court, what is there? The only document is principal's certificate, which I have annexed. Please see one example. I put it in the writ petition. Please see one example. Page 59 is one of the examples. This certificate is available for every petitioner. Please see page 59. I put for every petitioner. I am showing you just one example. Please see 59. This is Binodini Public Academy. Please see teaching experience certificate. This is to certify that because this son of so-and-so have qualification graduate, he has 9 years of experience. He has joined the school on 13 Jan 16, is still serving the school to the best of his duties. So this certificate is available for every petitioner, page 59 onwards. Continues for every petitioner. At page 68 is the other petitioner. So ultimately, my ladyship, what I am trying to reach at is that once the Honorable Supreme Court has given a finding on a particular aspect, this Honorable Court has followed it. At least 9 different states have followed it. Punjab has followed it. KBS has followed it. Multiple states have followed it. West Bengal has followed it. Everywhere, the only document to show that I was in service is this experience certificate. There is nothing more required. Plus, very, very important, there were previous recruitments done by the same very state. It is not as if we are being recruited for the first time. Please see the document that they asked us in the previous recruitments. Please see 638 for a minute. They never asked for all these 7-8 documents. At 638 is the notice of a previous recruitment for us. At 638. Ladyship would see para 1. The candidates must attend the physical document verification along with all relevant original documents, copy of online application, self-attested photocopy set of all documents. There is nothing that I need to show for in service. The advertisement is just 1 page prior, where none of these documents are mentioned. And not just that, ladyship, they have similarly placed ODL candidates who have done a course from the state SCERT also. None of these documents are being asked for. So why should there be a partiality qua me is the primary argument that I am trying to canvass. In this backdrop, my ladyship would please come back to the impugn notification. The reason, and please see 54 with me for the last time before I proceed to make my prayer. 54, my ladyship, what is the problem? One, there is no power. Under which provision of law at 54 is the state asking for these documents? Which provision of law? In fact, BTR has also implemented it, ladyship. Honorable Supreme Court 5 days back has passed an order in BTR's case where they have to issue appointment orders. Please see 54. Now they say appointment letter and accepted joining report of the applicant. I am giving the experience certificate which was required as per the original NCT notification. Minutes of social management committee of the school in respect of the appointment. How can I have it, my ladyship? I am an applicant who had taught in a school 8 years back. Where do I get this from? What is the power of asking for this document? Then see photograph of attendance register. Unfortunately, ladyship, post 2019, post COVID, most of these schools have closed. The cutoff date as per Honorable Supreme Court's order is 10th August 17. Was I teaching on 10th August 17 is the thing to be seen. I have produced experience certificate for everyone. Now, where do I get these attendance registers from? If the school has closed 5 years, 6 years back. Then please see the next one. A certificate issued by the school authority, which I have already produced. That is the only thing that I have. Salary statement. Most of these schools have paid salary to me in cash. Where do I get all these things from? My ladyship would understand that, would appreciate the fact that we are not the principal of the school. We are some schools teachers teaching in the primary school at some meager amount. And then the UDIS records. I must also say these UDIS records are not even mandatory even today. Every school to have, like we all of us have Aadhaar cards. Similarly, schools will have these UDIS records. The state has not mandated these UDIS records even till today. They'll mandate it from the next very year. Okay. So therefore, my ladyship, my interim prayer is this. Because there are two notifications which say that counseling verification has started from 27th onwards. The second is starting from tomorrow. We'll give that proof. I'll request my colleague to just hand over that proof where it says that Friday the first counseling has started and the second one is starting from tomorrow. Either my ladyship would consider staying them, because unless they follow the circle or the square covered by the Honorable Supreme Court, it cannot go. Or my ladyship would say that they should not insist for anything over and above the experience certificate subject to outcome of the writ petition. I have absolutely no problem. Because once I go, all of these documents are not, they do not have the power to ask for it. I don't have these documents because the Honorable Supreme Court never said. The state gave all these in-service documents or details to the NIOS. Let it be stated at least these provisions where these other than the experience certificate, if anything is asked for, let it be stated till the next date of hearing. Or the process may be kept in abeyance. The problem is this, that if an interim order today is not passed, the document verification last will conclude by 8th of July. That is the last document verification to be completed, and there are about 2,000, about 4,000 students in the candidates in the list. About 3,572 candidates are in the list. If the document verification is complete, then there'll be a new cause of action that will come. And it is not as if I filed today. I filed it at least 6 days, 7 days ago. But they released the document verification list 2 days ago. So therefore, my ladyship, my humble prayer, and I am so grateful for a patient hearing. My humble prayer is twofold. One, either kindly stay this process so that this issue of what can they ask for, or I'm so grateful, ladyship.
Lawsuits. First of all, this petition was filed on the basis of an apprehension lawsuit. On apprehension day, their candidacy will be rejected by the impugn order. That impugn order, what is the impugn order lawsuit? Page 54. And before the lawsuit may kindly turn to the annexer, they have annex as page 623 lawsuit, which is a judgment by the Honorable Supreme Court lawsuits. 623 lawsuit may kindly turn to 623 para 40 lawsuit clause 5, whereby they were allowed by the Honorable Supreme Court lawsuits. May I read this? We clarified the source of the teachers who were page 623 lawsuit. 623 para 40 clause 5 lawsuits. This is judgment passed by the Honorable Supreme Court lawsuits, whereby it is stated that we clarified that such of the teachers who were in employment as on 10th of August 2017 and who completed 18 months of DLED ODL program through NIOS before 1/4/2019 shall be considered as valid diploma holders for the purpose of applying for the institution. And accordingly, we have applied lordships. We have allowed them to apply lordship. They have applied. And next, lordship. We direct the respondent authorities to consider the candidates of such appellants who were in service on 10th August 2017 and that who on verification lordships. There's a question of verification is their lordship. So why they are afraid of verification?
No, I'm sorry, they are misreading.
The verification is continuing till 8 lordships, 8 of this August, no, July. And thereafter lordship, there also lordship, it will not complete them. Then if there's any absentee during this period, 27 to 8, then we'll again call them. There will be 4 sessions will be held there after 8 lordship. Let them appear, let them file, submit their lordship documents, whatever they ask for, and this notification doesn't contemplate that they will be rejected lordship. Where is the they only on application they have filed this petition lordships? Whether the lordship will allow this petition? There's no question of issuing any interim at this stage. Let them appear and submit all the documents lordships. Why they are afraid of?
No, as per their intention, they don't have those documents.
Whatever documents they have,
that can be.
Have taken any action against them, whatever have rejected their candidates and lordships? No.
Till now, no.
Till now, then where is the question of filing this petition on application lordship? And verification process is still continuing, and it will be continued thereafter also. And during this period, if there was anyone absent from this verification process, they will be again called for lordship. There will be another 4 round of session to be going after 8th of July. So at this stage, no lordship issue notice, let it fix immediately after vacation. I will take the instruction from the authority lordship.
Learned counsel is trying to mislead. Kindly see what he was reading.
No question of mislead.
One second, please. I didn't utter a word when he was speaking. Please see the first page of the paragraph that he was relying upon. Please see 597. The judgment that he is reading is of West Bengal. It is not of this court, or it is not concerning Assam in any manner. I appeared in this matter, so I can very categorically say, please see the first page of the paragraph that he was reading. Please see 597. It does not concern Assam. 597, if my ladyship would see the paragraph that he was reading, it is Kaushik Das versus State of West Bengal. 597. And the issue, one second, sir, if you don't mind. The issue in this matter, my ladyship, was that the allied had not given TET. That is recorded in the judgment. If you will please see this judgment, this is not the main judgment of 4961. In fact, if he wants to see, kindly see a judgment. Please see 597 for a minute. This is concerning only West Bengal. And this is an SLP against an order of the High Court. In fact, a similar judgment has been passed by the Honorable Supreme Court at page 585 for Uttarakhand, where they have not spoken about verification. Please see 585. What is my learned friend referring to? Please see 585. I have argued this judgment very well before the Honorable Supreme Court. Please see 585.
Now, ultimately, this
sir, 1 second. Please let me complete, if you don't mind, sir. 585, my ladyship, is a judgment pertaining to Uttarakhand, and see the operative part at the operative part, my ladyship would see, comes at 593. There is no question of verification. Please see the operative part. 593, para 21 is important. Indisputably, the other institutions would also include the schools run by the state government. At 593, para 21, I am reading. And then see 23, very, very important. We therefore direct the state government to consider the claim of the applicants in accordance with clarification to so, and if the applicants are found to be eligible, to appoint them in accordance with law. Now, it is my case that as per the advertisement, all of us are eligible. We are meeting the eligibility criteria. It is not my apprehension that they will reject me. I am questioning the source of power. My ladyship, if the impugned notification is seen, it does not even disclose the source of power. How can a government release a notification without justifying that what power does it have? Please see 54. Not even a whisper. The only thing that they are saying is we are relying upon Supreme Court judgment. The Supreme Court never said that you can ask for these 8 documents. In fact, I showed those documents before the Honorable Supreme Court. It was the state's duty to tell that who is in service and who is not in service. Today, going the clock backwards after 8 years, what purpose would it be met? So therefore, ladyship, it is not right to say that it is my apprehension. I am not apprehending. I am challenging the very source of this notification. And that I can only do if I. So therefore, my ladyship, please kindly consider, because ultimately it's 3,500 people. Today, if it is not state, there will be 3,500 more petitions coming in, because ultimately, if you please see the opening lines of 54, it does not talk about anything else, only the Honorable Supreme Court's order. Honorable Supreme Court order does not say so. It only says you are.
On page 37, paragraph 13.16, it is the apprehension. The petitioner reasonably apprehend that their candidature may be arbitrarily rejected.
Well, that is one of the grounds. I'm sorry. And
Why
there are at least 8 more grounds.
Let them appear and verify whatever document they have lost.
There are at least 8 more grounds.
Action, then they can come to this honorable.
No, I'm sorry. I'm challenging the notification. Please see my prayers. Please see my prayers.
Pleaded they on apprehension that they'll be arbitrarily rejected, and they've approached this honorable court.
Please see my prayers at page 48. It is not just apprehension. I'm sorry.
Outside instruction in this case.
Well, ladyship, the writ petition cannot be read in bifurcation. I'm sorry. Please see my prayers. My prayer is very clear that except experience certificate, 1 second, sir.
Anything that we will take any action, only ask that.
My ladyship may record their statement and they will not take any action. They will do the document verification and not take any action. I'm happy with that.
They have stated that they will apprehend.
Please see my reliefs. It cannot be that both of us keep arguing at the same time. Please, sir, you can conclude, then I will put my word. Please.
And this is not a case to be filed in the vacation court also. Though.
I'm sorry, my ladyship. I'm sorry. If I'm challenging a notification of 17 June by which the verification has to be conducted from 27 June and 1st
They filed this case on 27th. They have listed it today.
I have filed it on 25th. We have mentioned twice, my ladyship. The registrar said, please move it in the vacation court. My concerned colleague is there. Twice they have tried to mention. So, my ladyship, one of these prayers is very, very important. I will urge my ladyship to consider one, either staying it, or the document verification may happen without the experience certificate. Third, the most reasonable I am trying to say, let the results not be declared. Let the results of document verification not be declared, because then, 1 second, sir, what is this apprehension, please? Let the results not be declared so that the equities can be balanced. What would happen if the results are not declared till the next date of hearing? At least this issue could be decided.
The result is so far most probably till 8th of July the verification will be there, and then only as Master Authority has submitted that 4-5 rounds of the reassessment.
My ladyship, there is nothing on record.
There also.
There's nothing on record.
That's why it's not a question of result is not so thing.
No, we are not.
Anyway,
unfortunately, there is nothing on record. There's nothing on record.
Yes.
Okay, I'll pass the order.
Yes.
My ladyship may at least consider. My ladyship may kindly consider there is nothing on record to say that after 8 July it will continue. There is nothing on record, not even a single paper. So therefore, ladyship, if nothing is done at this stage, the entire petition will become infructuous, because I am challenging the basis on which this notification has been issued in clear violation of the Honorable Supreme Court's order. The specific document that I showed, my ladyship, I'm sorry.
There's nothing on record. There's
1 second, sir.
1 second, please.
Have some courtesy, please, sir, if you don't mind, sir. Please. Ladyship, those documents that I showed clearly say that the only document is experience certificate. I understand, my ladyship.
Yes, I have understood your submission.
Yes. So only one of these 3 interim prayers may be considered, or else this writ petition will be infructuous. I'm not saying make it an interim, make it given add interim order till the next day. Please have it at any date as convenient to the learned government council. But until the next date, this writ petition should not become infructuous. Let them not take any action on these document verification. Let them not publish the result of the document verification. At least that much can be done. I'm being fair to the court. I mean, I'm being most fair to the court. They don't stay.
Pardon? What is submitted?
The impugn notification doesn't reflect that we'll take any. We have only asked them to submit the documents only.
Ladyship, they take 24 hours.
Arbitrarily. On application, what are lost?
Within 24 hours. Within 24 hours, they will publish the result. They have done it in past. And I have come well in time. If this interim order doesn't come, the problem is it will become infructuous. Please see.
Nothing will happen.
Okay.
My ladyship may record his statement, then nothing will happen. I will be very happy with that.
Oh no, that statement I'll definitely record. I will record that statement as I submitted that.
Then nothing.
5 rounds of
recorded time, I'll be more than obliged. That till next date, whatever date, nothing will happen.
Okay.
And also, that Supreme Court has directed the verification of page 624.
That is most probably in, as he submitted, it is the connection of the
West
state
Bengal
of
only.
Bengal.
And they have relied on a Uttarakhand case losses. They have
Uttarakhand
relied
and
on
West
Uttarakhand
Bengal.
case, and now I am relying on the that
State of West Bengal.
Yes, it was
West Bengal, the
that
issue is
Uttarakhand
different.
document losses.
If my ladyship would see
By the
the
Supreme Court losses, is binding on all. Losses.
No, my learned friend did not have the
Anyway,
opportunity to assist the Honorable Supreme Court in that
last of
matter,
July
but I
document.
had.
On
I
20th of
had
July.
the opportunity. The issue there in the judgment is written. It is written that the apprehension of the state is that most of these eligible teachers would have not qualified TET, and hence the verification comes into picture. It is not the apprehension here that we have not qualified TET. So they are mixing two issues. I can say it with responsibility because I argued that matter.
This will go only under
And that is recorded in the
on the final hearing.
Okay.
I'm sorry.
20th of July losses.
You need on 28. Okay.
My ladyship, 28th may be slightly difficult. Can it be a day thereafter?
Thereafter.
Yes. Can it be 30th if possible?
30th.
30.
Yes.
Okay. 30.
And but my ladyship may consider on the interim prayer and
Pass the order.
Losses. That will.
I'm so grateful.
I heavily objected regarding
Well, let him object, but at least his statement may be taken into account because it will become infructuous, my ladyship, and we are 3,500.
Okay.
And I must also mention 8 states have implemented without asking for anything else apart from the experience certificate.
That you have already submitted. Yes.
Yes, KVS is one of the most important.
West Bengal has seeking similar kind of losses certification.